Stop using the sad scheme to freeze counterfeit accounts. Suing 500 anonymous sellers at once is a shortcut that federal judges are starting to punish with dismissals and sanctions. Here is the bulletproof, compliant way to protect your brand without risking your reputation in court. Step 1. The John Doe. Filing. Don't sue a list of strangers. File against John Doe for the specific infringing store. Then use expedited discovery to force platforms like Amazon or PayPal to reveal the true identity of the seller legally. Step 2. The nice to have. Cease and desist. Before the freeze, send a cease and desist letter. If they ignore it, you have proof of willful infringement. This destroys their innocent seller defense and entitles you to treble damages later. Step 3. Respect the Hague Convention. Don't ask to serve via email just because it's fast. Initiate formal service through the Hague Convention. Then ask the judge for a temporary restraining order, TRO, to preserve the assets while that formal service is processing. Judges respect plaintiffs who follow international treaties. Step 4. The Lanham Act hook. Argue for an accounting of profits. This specific legal remedy allows the court to freeze funds derived from fake sales to ensure they aren't lost, satisfying the strict requirements for an asset freeze. Alternative, the private freeze. If court is too slow, use Amazon Brand Registry or eBay VeRO. Let the platform freeze the funds based on their terms of service. It's faster, cheaper, and 100% compliant.